Hello everybody, this is the promised homework review video. I'm actually going to break this into two videos because with 6 questions, this video could get a little bit long, and if your internet connection is like mine, YouTube might not like that very much. Anyway, so in this portion of the video, I'm going to be talking about the questions that were at the end of Chapter 5. So that is questions 3, 5, and 8. This is page 130 to 131. I apologize, I've got the actual cases themselves up on another screen here if you're wondering what I'm looking at. So let's start with number 3. Number 3, the main question is a business responsible for the actions of its employees or agents, even if those agents or employees are acting contrary to the policy of the organization? And this was a Sherman Act violation, which is really sort of a big deal. It's a federal issue, a federal regulatory issue. So what happened here? The question asks, what was the result of the appeal? What was the result of the case on appeal? On appeal, the appeals court ruled in favor of the United States. They found that there was indeed a violation of the Sherman Act, and that Hilton Hotels was responsible or liable for that. That's because generally, as long as an employee or agent, we'll talk a little bit more about the difference between employees and agents later on in the class, but generally, as long as they're acting within the scope of their duties, in other words, they're doing what is basically their job, the fact that they do it wrongfully, or in this case illegally, is still the responsibility of the company that employs them. Now, if they were to, go out and commit a crime, go down the street on their lunch break and, rob somebody, that's not part of the scope of their normal duties. But in this case, dealing with supply companies was part of these employees' regular, job descriptions. So the employer is responsible for whatever they do in that position, even if it is a violation of the company policies. So I hope that was clear. So number 5, the case itself is not listed in your book. They direct you to a New York Times article, which I've been told some students aren't able to get to, that it's behind a paywall. If you've looked at other New York Times articles recently, you sort of have a number that you can see before they want to charge you money. Anyway, if you Googled it, though, you were probably able to find the outcome of the case. The FBI did issue a press release after this case was over. Basically, what you have is Martinez, who wants to blow up American soldiers. And he was, and I'll fill in some details here, he was actively recruiting people that he considered loyal to his extremist cause to participate in killing American soldiers. One of the people he talked to ended up being an FBI informant. And the FBI informant helped build this phony car bomb as part of a sting operation. Now, he then, of course, went and tried to set off this fake bomb. His attorney at trial argued that he was entrapped. Entrapment is probably the legal concept that movies and TV shows get wrong the most. You've probably seen this at some point, TV or movies. You have to tell me if you're a cop. If you don't, it's entrapment. That's not actually true. A cop doesn't have to tell you they're a cop if they're working undercover. You can only argue entrapment successfully in a very, very narrow set of circumstances. And the two main things I want to hit on, the two main elements of this, I think are the most important. First, the initiation of the criminal conduct, of the idea, basically, has to have come from law enforcement for it to be entrapment. So in this case, Martinez approached the informant with the idea to participate in a crime, in killing American soldiers. So Martinez initiated the criminal activity. He was the one who got the ball rolling. The second thing is that law enforcement had to have persuaded the person to commit a crime, and without that persuasion, that person would not have committed the crime. In this case, Martinez wanted to commit the crime, and so while the law enforcement agent may have given him assistance, he did not have to convince Martinez or persuade Martinez to do something. Martinez probably, it seems, would have done something anyway, with or without the help of this informant. It may have not been exactly the same thing, but he clearly had a plot that was of his own making. It was his idea to commit a criminal offense. So in this case, he is not entrapped. Successful arguments on entrapment are very, very rare. One of the reasons for this, one of the reasons it's not even used that often, is that it's what's called an affirmative defense. So the person has to admit that they did what they were accused of, but then say there's a reason it's justified. It's kind of like self-defense. If you kill somebody in self-defense, or you assault somebody, you hit somebody in self-defense, to use self-defense as your, your justification, you have to admit that you were the one who did it. And so if you aren't successful in claiming self-defense, you've admitted guilt. Same thing's true with entrapment. Martinez wasn't denying that he built and set off this fake car bomb. He's saying that essentially, yes, he did it, but it wasn't his fault. It was the fault of the FBI. So Martinez ended up getting sentenced to 25 years in jail, and he is still serving jail time on this, and will be, obviously. I believe he was sentenced back in 2012 or 2013. Moving on to the third one, number 8. This one is about Thomas Reese. Thomas Reese, I'm not sure if that's a typo in the book or if that's how the name's supposed to be pronounced. So he broke into a KFC. He terrorized the staff and stole a whole bunch of money. His roommate later turned him in. Great roommate, right? So the question here is, which offense has he committed? Was it burglary, robbery, or larceny? Now this does vary somewhat state by state, and so since this case occurred in Ohio, I'm going to talk about it under the context of Ohio law. Let me get that case up in front of me there. Okay, so in Ohio, the aggravated robbery statute says this. It says, no person in attempting or committing a theft offense, as defined by this other section of the revised code, or in fleeing immediately after such attempt or offense, shall do either of the following. 1. Have a deadly weapon or dangerous ordinance, as defined in another section of the code, on or about his person or under his control. So in this case, under Ohio law, it meets the definition not just of robbery, but of what's called aggravated robbery. Aggravated robbery generally, in most states, means that a weapon was involved or that somebody got injured in some way. You have to keep in mind that with criminal law, most of this is state by state, and so the exact details of how a state is going to interpret something as robbery or as burglary or as larceny may vary based on what state you're in. Your book gives you sort of the average, I would say, the most typical definition, the most common definition. But if you ever find yourself in a position where you need to figure out which one has happened, hopefully you won't ever be in that situation, but if you do, make sure that you refer to your particular state's laws and not to an overview. An overview can give you good guidance, but it won't necessarily give you the exact details you need. Okay, so that's the end of the first section of this video. I will be back in just a few minutes to talk about the questions at the end of Chapter 6.